if it's...
Sometimes my video, when I fix it, it interferes with the audio.
Oh, okay.
But what I normally do is just switch it on so that people don't think I'm a robot, and then I switch it off.
That's okay, Chief Justice.
Okay.
So I think it's fine. What we can do, perfect. We can see you, CJ.
That's good.
Fantastic.
Okay.
So I think we can now see most of our panelists. Of course, we are now running behind time by 6 minutes. Let me call the House to order and quickly call the Secretary General of Africa Judges and Juries Forum, Mr. Martin Masiga, to welcome you all. You have the next 5 minutes, Secretary General, to welcome the audience to this webinar. Over to you.
Yeah. Thank you very much, Justice, and my Lord CJ, and whichever other judges are present, ladies and gentlemen, esteemed guests, distinguished participants. I am honored this afternoon to welcome all of you to this important webinar on the state of judicial independence in East Africa, where we're going to look at the contemporary threats to our independence and mitigation strategies. This event serves as a platform for critical dialogue on an old subject, yet ever new. I guess it continues to be new even when so much has been written about it, even when so much has been said about it, because of its importance at the heart of any functioning democracy. We saw in 2017, for instance, in Kenya, with the breakdown of the rule of law, leading to a catastrophe where many people died because there was no confidence in the ability of the judiciary to render a decision that would command the confidence of the public. So the losing candidates in that election did not use the courts. But we saw what happened in 2013 instead, and after that, that when there was confidence in the judiciary, it was utilized to settle what was what have been very contested elections. But we have also witnessed in Ivory Coast a situation similar, analogous to that, when the court failure led to breakdown of rule of law and chaos in an entire nation. And so the importance and continued interest in this subject cannot be overstated. Many times, though, we tend to associate problems with judicial independence with infantile democracy. Yet, looking at it critically, one would see that this is probably a global problem. It's not just about the degree of democracy that a society enjoys or the level at which it is. Because we have seen, even in established democracies, that this problem continues to be a stubborn one. For those who have followed, you must have dealt with the issue, for instance, of the war that has been going on with in Israel over judicial reforms, with protests. As we speak now, in the US, you have a situation where a governor in Texas has defied a court a court order. You also must be aware of the disagreements between Poland and the EU, and also the many protests that have taken place in Poland since, I think, around 2017 regarding the reforms, judicial reforms that have been introduced by governments, which create greater space for a government in power, to dismiss judges, including the passage of the so-called Mazo Law in 2019, I think it was. It is said actually that since 2017, over 1,000 judges have been targeted. So 2017 is also when the disciplinary chamber, was introduced in Poland, and over 1,000 judges have fallen victim of the actions of this chamber. So in East Africa, we have progress when it comes to judicial independence, but we have also have had a number of setbacks. And I hope that we are going to hear from the presenters what progress has been made, what setbacks have we suffered, and what mitigation measures can we take as in our different capacities, as lawyers, as judges, as civil society organizations, and as government representatives for those who come from government, to improve the framework and the practice of judicial independence in East Africa. As I conclude, I would like to thank the our speakers tonight for having accepted to participate in this conversation. And I would like to thank the organizers of this webinar. In particular, I would like to thank Elizabeth and Justice for having organized the seminar. Thank you very much. Over to you, Justice.
Thank you so much, Secretary General of Africa Judges and Jurists Forum. And welcome participants to this webinar that has been co-organized by Africa Judges and Jurists Forum, ICJ Kenya, East Africa Law Society, Tanganyika Law Society, and the Southern and East Africa Chief Justice Forum. You will see on the program that is displayed on the screen that we have a lineup of very eminent speakers who will take turns to address us on specific themes around judicial independence. I will leave the moderators of the specific sessions to introduce the speakers in greater detail. But at this point, I would like to just point out that we will have Dr. Willie Mutunga. We will have Ms. Faith Odiambo. We will have Dr. Mercy Deche. We will have Professor Margaret Satterwade making presentations on different thematic areas. I would like to acknowledge amongst the participants, the chair of the board of Africa Judges and Jurists Forum, Justice Moses Chinengo, is here with us. We also have a member of our Judicial Elders Council, Justice Lillian Tibateno, also with us in the participants. They may make some contributions along the way. Without further ado, ladies and gentlemen, let me introduce the next speaker, who I think does not need any introduction, actually. He is the former Chief Justice of Kenya, He is a jurist and a legal academic. He is also the president of Africa Judges and Jurists Forum, Judicial Elders Council. Ladies and gentlemen, I have the honor to bring to the digital podium Dr. Willie Mutunga to make a representation, some remarks on a judge's perspective to the state of judicial independence in East Africa. Over to you, Chief Justice.
Thanks, Justice, and thank you everybody who is participating, the judges, lawyers, and African people. I've spoken on this issue before, so I'll probably not take 15 minutes. I always start with, I think we were very clear what judicial independence and judicial integrity is about. In most constitutions, this issue is decreed. When you look at the Kenyan one, it's very clear, and the history of why the provisions in the constitution degree independence and integrity. But I want to start by looking at the threats. Okay, when we talk about judicial independence and integrity, the threats that have been talked a lot about are the traditional ones, and those are, the executive, parliament, the corporate sector, whether national or global, and also the civil society. But I've always argued that there are other forces that, or other threats that, we don't talk about. We don't talk about the bar associations and their role in undermining the independence of the judiciary. I know a lot of bar associations will discipline lawyers who are known, to be subverting that particular independence. But there are cases where, the bar association actually don't do anything, and there are cases where, in the case of Kenya, we have had examples since the colonial period, of members of the bar that are threats to judicial independence. And then there are insidious ones that we don't talk about. We don't talk about incorruptible judges whose independence is subverted by their wives, their sons, their daughters, their friends, their communities, their churches, their mosques. That area, for me, it's very important to interrogate when we talk about judicial independence, because my experience as a judge, I've always said that my independence, decisional and institutional, was challenged by my community. Okay, and everybody knows that in Kenya, the politics of division are based on money and ethnicity. And so, I got many self-appointed characters, asking me, why are you building courts in far-flung areas? No courts in our, in our community. So those issues, religion, and so forth, are very, very important to interrogate, particularly when they can happen without the judge knowing. Okay, you know, your wife is taking bribes and you don't know. Maybe judiciaries will have to set their own intelligence systems so that they, you know, they don't rely on the state, you know, to deal with these particular issues. So yes, the bar, you know, I've talked to the family and friends. And the other threat is actually within the judiciary itself. Okay, the judiciary can be its worst enemy when it comes to, you know, to independence. I think we all, particularly in East Africa, we have histories of chief justices who in the past would give orders to judicial officers and judges. And basically say, you know, the president wants this done, or the district commissioner or the provincial commissioner. And that there's a history of that, you know, and in most of the constitutions, you see very clearly that issue is dealt with. And then the institution itself, if the institution is going to fight for its independence and integrity, it must be an institution, because judiciaries are not immune to ethnic divisions, to religious, you know, divisions, to you know, sexual harassments, and the institution itself becomes, you know, pretty weak. You have cases where within the judges themselves, they are bullies, and there are examples of that, where they, particularly when it comes to benches, you invariably find that within that bench there's somebody, you know, who is calling the shots. So we'll have to look at the judiciary itself. The judiciary itself has to operate as an institution and internally deal with these divisions, make sure that everybody protects the independence and integrity of the judiciary. We know that within the judiciary itself, judges know who the people who take bribes, okay? But invariably, they don't do anything. So we've got to ask the judiciary, you know, we've got to be saying the judiciary, you know, when you are, you know, implicated in this particular issue. And that's why the judiciary academies and institutes, when they meet during the annual colloquium, they should discuss this issue very seriously, because I think the discussion hasn't taken place, you know, within the institution, because we tend to give it to the Judicial Service Commission, and we also make sure that those who are, you know, who are suspected of taking bribes or doing whatever, in the case of Kenya, the Judicial Services Commission deals with it. Citizens can file petitions. Anybody can file those petitions. But what I'm saying is, the institution starts a discussion, you know, about this particular issue and seek, you know, solutions. Let me also say that because we're talking here about mitigation, what is to be done, and we've got to glorify the fact that although I've given all these courses of that undermine judicial independence, I don't want to give the impression that there is no resistance to those forces, because that will be wrong. It will be wrong not to acknowledge and glorify, you know, you know, there's echo in.
Yeah, it was from Justice Chinengo, but I have muted. He has muted himself now. Sorry about that, Chief Justice. Please go ahead.
I thought it was from some of the enemies who don't want to hear us talking about judicial independence. But that's comforting, Judge. So I wanted to make it very clear that as we discuss these issues, let's also glorify, okay, the courage of judges and judicial officers, and the fact that in most cases, judges from other jurisdictions come to give support to judges that are facing attacks, and that African and global, visitation, for protection is very, very, very important, because judges can be very lonely. And so as we deal with these issues, let's look at the gains that have been made, to glorify them, to document them, to keep on giving awards, although the awards that are given to judges also politically are double-edged swords, because some people might get targeted for it. The other issue about mitigation is this issue of judicial politics, tends to pop up, judicialization of politics, and it's another issue, I think, that has to be discussed, because the issue of judicial independence and integrity is a political issue. We can't avoid that issue, and I think what judges deal with is very political, and that's why, like in the case of Kenya, in the constitution, what are called court users committees that sit at every court, to talk to the judicial officers about their concerns. It's one way of building a following among people, because judicial independence that is not protected by the people themselves can never be successful. And I think that idea of seeking a following, making sure that our people also defend the judiciary when you get the executive or parliament, like is happening in Kenya now. There is always this view that the executive and the parliament own resources of the country. So you find politicians now saying, well, this judiciary is blocking our policies, and we're going to deprive them of their cars. We're going to do this and the other. It's all it's all over the place. The president is saying he has a mandate to disobey court orders. He's not, he doesn't realize that he's swore to uphold the Constitution and defend it and is respected, and that orders by judges are, he has the constitutional obligation to to obey them, because it's the judiciary that has a final word on what particular dispute it's all about. But I think we need, in fighting for independence, also deal with that issue very seriously, the issue of following. And it can be done through what I call judicial politics. I remember once the judiciary wasn't getting money for, I think it was during Maranga's, CJ Maranga's time, and the funds were withdrawn, and there were courts being built, and the construction stalled. And I think during that period, the judiciary was advised, and I think quite rightly, that the best way is to go to those places where the courts were, which where the construction wasn't proceeding, and talk to the people there, blame the governor, blame the senator and the MP, and just take the battle to politicians and others who think that the national resources belong to them, they are the custodians, so they can say this institution doesn't get it. And that's how they weaken. In our case in Kenya, that's how institutions are being weakened and starved of resources. And I think that that following that, talking to the people, whether it's through open days, the judiciary has to be to basically come out and have dialogue with the people, and particularly now that, like in the case of Kenya, there is a robust program on African justice systems. So there is access now to elders, to people about this and that kind of discussion. I think in Uganda they have also the counter. I don't know what the courts at the grassroots are called. So there is an opportunity to nurture and consolidate that following, so that when the politicians or whoever says the judiciary shouldn't get money, the people will also, speak up. And the last thing I wanted to say is, on this issue, in Africa, probably, I don't know, I can say that about Kenya, that because of our constitution, because of our judiciary, the judiciary has become, a very important institution. An institution, judges who have the audacity to tell the president that this particular statute is unconstitutional, and they're going on making these decisions because what they are doing, they are interpreting the constitution. And so I think it's very, very, very important that we realize how important the judiciary is. And the judiciary should also think about its role in the future. I always tell people that we've had elections, we had, military rule. We should also imagine a rule by the judiciary. And in the Kenyan constitution, there is a lot of debate now around Article 1 and Article 3 of the Constitution. Article 1, which says we have the sovereign power, and this power we delegated, to various institutions. And people are saying, if you delegate, you can withdraw that, sovereign power. So, going forward, you might find that those issues of what I call judicial politics become, very important. And I think it's important for the judges, the judiciary, to prepare for some of those disputes that, might get to court, where citizens say, we want to withdraw our sovereign power from this institution or from this one. And those matters, in the case of Kenya, under Article 3, will have to go to the, the judiciary. So thank you very much. I think I'll stop there, Justice, and thank everybody for hearing me. And yeah, that's it. Many thanks.
Thank you so much, Chief Justice. It is always a pleasure to listen to you speaking on this subject. Just to flag out for our participants to keep thinking about this as the webinar continues, I think there are a number of issues that were raised by CJ Willie Mutunga. But more importantly, he delineated the sources of threats against judicial independence. And he identifies the Bar Association as one of the sources where these threats emanate from. But he also points out that there's a need to investigate the role of sectarian interest groups, such as religious groups and ethnic groups, and the influence that they have on judges. He also highlighted that the judiciary itself can be a source of these threats. But I think it is also worth to flag out this point that he raised, that it is the role of the citizens, it is the role of the public to actually defend the independence of the judiciary. And this is something that we must not forget. Thank you so much, Chief Justice. At this point, I would like to also remind our participants that you post if you have questions, thoughts, comments, please post them in the Q&A section. At the end of this webinar, we'll have a plenary where the panelists will discuss those questions in detail and attempt to respond to them. At this point, I would like to then hand over to my colleague, who also represents an organization that has been a partner in organizing this webinar, ICJ Kenya. Over to you, David Mburu, for the next session. Thank you.
Thank you so much, Daktari, for that wonderful first session. Thank you, CJ, for leading us in that discussion. For our next session, we have Faith Monyi Odhiambo. Faith is an experienced advocate with an illustrious career spanning over 13 years. She is currently the Vice President of the Law Society of Kenya, and she is also an educator at the University of Nairobi. Currently, Faith is also contesting for the LSK President, and her illustrious career has been characterized by dedication to justice, mentorship, and innovation. Faith's involvement in the legal sphere has gone beyond the courtroom and the classroom, and she has been able to play a pivotal role in various legal organizations, exemplifying her commitment to the profession, her tenure as a council member and board secretary to FIDA Kenya, and her impactful service as the Nairobi representative and vice president of the Law Society of Kenya highlight her leadership capabilities and her dedication to the welfare of the legal community. I want to welcome Faith, and Faith, as you take your moment to discuss with us, I want to pose this question. In your capacity as a practicing advocate and a leader in the legal sphere, please share with us insights on the current threats to judicial independence in Kenya and the broader East African region. Welcome, Faith.
Thank you so much. First of all, just to say it's an honor to be amongst all of you. Chief Justice, it was an honor listening to you as well, and all the presenters, my senior colleague, Mercy Decha as well, who is present. Now, as I look into your question and answer, in East Africa, what are part of the challenges as a practicing advocate and teacher of law? I'd want to say tongue-in-cheek that we don't have experience practicing in Uganda. I hope our counterparts will allow us to soon start practicing there as well, in the spirit of the East Africanism. But as we delve into some of these challenges that we have, I want to shed light. Maybe I would touch on, I start with Tanzania. When we recently had the last East African conference, and it was honored by the president of Tanzania, and in her remarks, she indicated her unhappiness with the East African court, particularly because the government had lost so many cases in that court, and they felt that it was mostly those cases were being presented by the civil society, by the Tanzanian bar against the government, and their insistence on leaving that court. Why? Because they felt like all decisions were against them, and hence they were corrupt. Closer home, when you go also to Uganda, I raised a concern recently when the president intervened in a controversial judicial decision regarding the auctioning of a national mosque, prompting questions about the separation of powers and the autonomy of the judiciary. In his letter dated 7th December, the president indicated to the Chief Justice to review that matter and restore sanity to the judiciary. And further, when one of his district commissioners refused to appear before a court, citing that that court was corrupt, and therefore it would be an erosion of public trust in the legal system, and they could not agree to attend to that court. Now, when I come closer to our personal jurisdiction, we recently have seen a spate of conflict between the judiciary and the executive, and the law society as well playing its part under Section 4, when the president made some roadside remarks regarding pending decision by the judiciary. It was actually before the Court of Appeal on the housing project, alleging that the courts were corrupt and that they would not obey court orders that were contrary to the agenda of the government. And based on that, I would like to talk about the several threats that I feel as a practitioner that are a big problem to independence of the judiciary. I'll start with the executive. Now, when you see an executive that is directly attacking the judiciary without even following the proper channels, we ask ourselves, is it because there's actual corruption, or is it because the courts have made a strong stand and the executive find that because they have the platform, the political platform, and to call for public appeal, that's the opportunity that they can use to attack the judiciary, because in most instances you'll find the judiciary will speak by the power of their pen. Now, the Kenyan situation today, when we see the head of state personally attacking members of the judiciary, is quite sad, because we see a situation whereby, as much as they're saying there is corruption, and I don't doubt there are elements of corrupt judicial officers, but the question is, when did they realize that the judiciary was corrupt? Is it because there's a project that is the head of state is personally interested in, or he feels strongly about that if he has not followed the due process of the law and the courts have held the same, then therefore they are corrupt? And also we look further that what has the executive even done with regards to corruption that is been there day in, day out at in the cabinet offices, the public offices that we see? We don't see anything being done with regards to corruption, but we see threats, veiled and open threats being directed to the judiciary. And so executive is one of the main threats, and particularly in Kenya, this current dispensation, we feel that the threats levied against the judiciary are an attempt to erode the independence and to guide or push the pen of the judges to a particular direction. That there's all praise and pomp and promise of increase of monies and gifts here and there, as long as they make the right decision in accordance to the executive. With regards to Parliament, we see a situation whereby there are court orders barring any, and I want to use the Kenyan situation for this particular instance. There are court orders in place that the housing project should not proceed. And we see Parliament, even when they were actually in recess, the chairs of these two committees on housing and finance coming together and sitting and calling for public participation, irrespective of there being court orders barring the same. And so Parliament is also a huge threat. We see a situation where there's that particular fear that the executive is coming together with Parliament in attempt to undermine the role of the judiciary. So Parliament, as much as we are supposed to expect to see Parliament, particularly when the two speakers are advocates and have an oath that they have sworn to uphold the rule of law and defend the Constitution, are the same ones allowing such a situation to continue, then we see the state in which the nation is going to end, the challenges that the judiciary is yet to face in the coming weeks ahead. And I also say the judiciary can also be its own threat. And why do I say that? Is when we see judicial officers bowing down to the pressures of the powers that be. While I say there's no problem on the head of judiciary meeting with the head of state, as well as the speakers in Parliament in any given period, when there are issues to discuss, I think there's no problem at all for those offices coming together. But when we see at a particular time that there's challenges with regards to independence of the judiciary, they're being called to have a sit down. And in the end, there's no open or proper, clear conclusion of what that sit down was about. If the president was raising concern about corruption, what has been done about that corruption? What have they agreed about corruption? Can you actually sit down and discuss and say, let's negotiate about corruption, or corruption must be dealt with firmly? We already have structures that have set in place to deal with the menace of corruption. Why is there a need for a sit down to come and say, we're going to do 1, 2, 3 about corruption? The laws that are there, the institutions that have already been set in place to deal with this menace. So we also read malice, because as the head of the judiciary, as much as her trajectory or the Chief Justice trajectory would be to, come up with an amicable solution, but also as the head of the judiciary, there's that expectation that she carries the mantle and the weight of that arm of government to also protect the judicial officers that are standing in the gap, that are risking life and limb to uphold the rule of law. We come from a situation where in the East African region, there's always this nuances that the judiciary is a weaponized arm of the executive, that by crippling the judges, you can be able to use the judiciary as a way to deal with your enemies, that you'll be able to ensure that either they are locked up. And if you just even look at some of the history of in Uganda, the kind of decisions that were being made with regards to any opposition leaders, you look at the situation even that we saw at Tanzania at some particular point, that even the head of the bar in Tanzania had to flee the country. We look at the position in Kenya before, when we still had one-party state. And during the Ringera purge, most of the judges were saying they had no choice, and it was the question of the red phone. So these are part and parcels of the challenges that we see, and we are hoping that the head of the judiciary might realize that the possibility of moving back to those dark ages are not far-fetched. And sitting as that head, that there's that expectation that they should stand strong, they should stand firm and protect the judicial officers that are doing the right thing, and to also hold firmly to the position that they have taken. I would also say the bar can be a threat, and also the bar can be, at the same time, your last front to stand beside you. We have seen in Tanzania, the head of the bar during the late Magufuli's time coming out quite strongly, particularly where they felt that as much as the president was loved and popular, they stood against any tyrannical decisions that were made, to an extent that even there was risk to his own life, and he eventually fled the country. And he reached out to members of the various bar, including in Kenya. And we have also seen members of the Ugandan bar and Tanzanian bar reaching out to the Kenyan bar for protection at different instances. And the bar can be a strong front, and I say this in particularly in the fight to protect the rule of law. We have the opportunity as the Law Society of the East African region to also stand firm and support any bars or any judicial offices that are under attack. We saw recently East African Law Society as well came to join hands with the Law Society of Kenya as we marched on the streets fighting for the independence of the Kenyan bar. That sort of coalition coming together and standing for, the rule of law and standing together firmly is quite laudable, that they saw it fit that they, support the work that the judiciary was doing. As long as they are doing the right thing, let us support the work that these judges and judicial officers are standing in the gap to uphold the rule of law. The challenge that I agree with Justice William Mutunga, that as well as the bar can also undermine the role of the judiciary. When we have unfair attacks against the judiciary by members of the bar, particularly on unfounded reasons, I think it's a responsibility as well for members of the bar to also stand high and stand tall, that if they know the proper judicial processes, if you feel these judicial officers that are corrupt, then you know the proper channels to lodge your complaints, to lodge the challenge that you have against those judicial officers. It's your duty not only as an officer of the court, but also as to uphold the constitution and the oath of office that you took as an advocate. So advocates also should not, members of the bar should also not undermine the judiciary unfairly and unfoundedly, because to that extent, I agree that they can also be a threat to the judiciary. With regards to the civil society, I think that David Mburu comes from ICJ, but I feel that particularly the last 2 years, we're not seeing the civil society coming out as strongly as they ought to have been. When you see the judiciary is under threat and the civil society is quiet, then I believe and I feel they become part and parcel of the threats that are there. In so many instances, the work of the civil society, particularly raising their voices against injustice and abuse of the court processes and derogation of the judiciary, has been a strong foundation to support the work that, to ensure that the judiciary is independent. And so the civil societies have an important role to play. And when we see elements of interference in these jurisdictions around the East Africa, and we see our civil societies quiet, the question arises is, why are they quiet? Is it that they're in agreement with what is happening, or there's an actual problem also with those institutions? Or, then also similarly in bed with government, or they are scared for their own lives? The civil society remains one of the best and the strongest players in this judicial system. And I hope to see more of the voices of the civil society. I also say the public has a role to play. As much as there may be emotions on different issues regarding the kind of decisions that are made. But I think as members of the public, they also have an important role to play to defend the judiciary. I would say that even when we see political leaders trying to whip up the emotions of the members of the public to turn them against institutions such as the judiciary, it's your civic and a duty as a citizen to also interrogate some of these things that politicians try to whip your emotions, because the judiciary are the last wall for justice, and they stand in the gap against a tyrannical government and an overbearing parliament. And so the members of the public also have a role to play. And if they also fall prey to the whipping of their emotions by politicians, then they also will end up standing as a threat. So I say as a practicing advocate who has practiced in some of these regions, I would want to end by saying that the rule of law is precious. And in third world countries, the nuances are always that the executive controls the parliament, the executive controls the judiciary. In Kenya, we have fought so hard for the 2010 constitution, and it would be painful to see us going back to that situation, that we lose the beauty of us being able to have a strong voice, to be able to criticize the executive, criticize parliament, to be able to raise complaints and also seek justice before these courts. The courts are the only opportunity that you will be able to, raise petitions to remove certain corrupt, even politicians and corrupt members of the executive from being able to hold certain offices. We have seen judicial decisions that have been progressive. We have been able to remove and prevent certain members that had served in the previous dispensation and they were barred by the same judiciary from having to hold office. So it gives hope that they are not above the law. And so I say the threats to judicial independence must be hard fought. When we have an independent judiciary, we have that hope that we can at least bring an equalizer to everyone. That as much as it said in the animal farm, that all animals are equal, but some animals are more equal than others. The hope that we have in an independent judiciary is that it equalizes those inequities, that you're able to present your case, you're able to stand before the halls of justice and get justice when you raise your rightful cause. So with regards to all these threats that we have, I would say that as the bar, we'll try to continue striving to uphold our oath of office, to fight for the independence of the judiciary and to protect the constitution that we hold dear. It's a responsibility that is borne upon us as lawyers, and it's a responsibility as a citizen that we fight to uphold the rule of law. Thank you.
Thank you so much, Faith, for that wonderful presentation. Thank you for the quick reminder and helpful reminder that the judiciary remains the bulwark against excesses that are a threat to the rule of law. Thank you for the reflections on the role that the executive plays, the legislature, and the judiciary itself, moving also to the bar, civil society, and the public. I think as you were talking, things that were coming out is that authoritarian regimes are truly then a threat towards judicial independence. And these authoritarian regimes have led to the clawback on judicial independence. And we've seen this, like you've illustrated in your presentation. So thank you so much, Faith. I take this moment to invite Justice to invite the next speaker.
Thank you, Ndugu, David, for that. I'm looking at the number of participants. We are currently sitting at 180 participants. This is very encouraging. The numbers keep going. We started at 90, so that's very good. Without further ado, let me call onto the digital podium another eminent jurist, lawyer, and academic who needs no introduction, but for purposes of protocol, I will. She is the United Nations Special Rapporteur on the independence of judges and lawyers. She is a faculty director at Bernstein Institute for Human Rights and Global Justice. Her name is Professor Margaret Satterthwaite. I hope I pronounced that correctly, Meg. I'm used to calling you Meg, but I can't do that on this platform. So
it was perfect.
Special Rapporteur.
Thank you very much. And I appreciate your perfect pronunciation. In fact, it is a true honor to appear with you today, though I'd much rather prefer to be in Nairobi or Kampala or Dar es Salaam instead of the cold and gray New York where I join you from. I'd like to very much express my gratitude to the Africa Judges and Jurists Forum, and especially to Dr. Justice Madbadzenge for their work in organizing this event, and especially in the work all of you are doing to bring to the attention of the public the contemporary threats that judges are facing in East Africa. Your honors, colleagues, I want to start with a brief and hopefully not too boring overview of my mandate as Special Rapporteur on the independence of judges and lawyers. So what is a Special Rapporteur? We're commonly called mandate holders. We're independent human rights experts who are appointed by the Human Rights Council of the United Nations. We do not work for the United Nations, but instead serve voluntarily as independent experts. There are thematic mandates that look at specific topics like the independence of the judiciary, but also issues such as torture, the right to health. They really range across all of the kinds of rights we have: civil and political, economic, social, and cultural. And then there are also some country mandates that focus on very particular countries. So let me tell you briefly about the main activities of a Special Rapporteur so that you get a sense of how you might engage with mandate holders if you would want to bring our attention to certain human rights issues. So we have really three main functions. The first is to address individual complaints of rights violations. And so people can send to me issues that are arising within my mandate, so things that are impacting the independence of judges or lawyers. And I then engage in a series of correspondence with the alleged violator state or non-state actor. And that's a process that results in a public statement called a communication. That's the first thing I do. And then the second is to conduct 2 official country visits annually. And these are at the invitation of the government. And I there report on in-depth and issues relating to the independence of judges and lawyers, and then make recommendations to address the concerns that arise. Finally, I produce 2 thematic reports per year. I prepare one and present it to the Human Rights Council in June, and then I prepare another and present it to the General Assembly in October. And those can touch on any issue relating to my mandate. So what is the theory of change behind the impact of special procedures? This depends a lot on the mandate, but in particular, special rapporteurs have soft power. That means that our work impacts human rights by raising public awareness, by spotlighting cases for governments and the public, and by documenting rights situations for monitoring. We engage in dialogue with states and governments to offer technical advice and to contribute to development of international standards. Our thematic reports provide hopefully influential interpretations of human rights, and sometimes they are referenced in judgments by courts or picked up by academics. Perhaps most importantly, we have really the obligation to speak truth to power. So when we see violations of human rights and are able to determine that they're well-founded allegations, we speak out. So that's my role, and therefore I want to engage with you all in ensuring that you send me information about violations of the right to judicial independence, of the obligation of judicial independence. So I assumed this role November 1st, 2022 for an initial 3-year term. And this mandate over time has worked very hard on trying to develop the standards around the independence of the judiciary and the role of independent lawyers in upholding the rule of law. So how does my work and the work of the mandate relate to rights that are enshrined in international human rights law? First, Article 14 of the International Covenant on Civil and Political Rights guarantees the right to a fair and public hearing by an independent and impartial tribunal established by law. And this right must be affected and implemented by tribunals that are truly independent and impartial. In General Comment 32, the Human Rights Committee, which interprets the International Covenant on Civil and Political Rights, clarified that the requirement of competence, independence, and impartiality of a tribunal is an absolute right. It cannot be subject to exception, and states must take specific measures to guarantee that independence. So that means that even if there's a public security crisis or some natural disaster, the right to access justice and to access an independent tribunal remains. And that is very, very important for any country that's undergoing a crisis or an upheaval, that right really be retained throughout. The other really important set of norms is the UN Basic Principles on the Independence of the Judiciary. These principles lay out the requisite of independence in the first principle, which says, the independence of the judiciary shall be guaranteed by the state and enshrined in the Constitution or the law of the country. It is the duty of all government and other institutions to respect and observe the independence of the judiciary. So the principle of judicial independence derives from the core guarantees of the rule of law, in particular, the principle of the separation of powers. According to this principle, the executive, the legislature, and the judiciary constitute 3 separate and independent branches of government. Different organs of state have exclusive and specific responsibilities. By virtue of the separation, it's not permissible for any branch of power to overstep its bounds by invading the other sphere. Former special rapporteurs on the independence of judges and lawyers have underlined the independence of this principle, stating, quote, the principle of the separation of powers is the bedrock upon which the requirements of judicial independence and impartiality are founded. Understanding of and respect for the principle of the separation of powers is a sine qua non for a democratic state. At the international level, the sources of this law are to be found in conventional undertakings like those I've just discussed, customary obligations, and general principles of law. The underlying concepts of judicial independence and impartiality are general principles of law recognized by civilized nations in the sense of Article 38 of the Statute of the International Court of Justice. So that means that this basic set of principles applies no matter whether a government has ratified the International Covenant on Civil and Political Rights, because that right is so fundamental that it is enshrined in customary international law. The principle comprises both institutional independence and individual independence. Institutional independence is what we've been talking about. The judiciary as an institution has to be independent. And it also has to do with individual independence. And that is the requirement that judiciary and judges are not subordinate to other public powers, but they're also not subordinate to a political party, for example, or a sense of bias or discrimination that they might bring with them to the bench. A strong, impartial, and independent legal system plays a central role in guaranteeing individual rights. That is true of all protected rights, civil, political, social, economic, cultural, not just the ones that are enumerated in the different treaties. Judicial enforcement of rights is important for so many reasons, because such enforcement helps to articulate and develop the jurisprudence of rights, because enforcement can lead to reparations for those impacted by rights violations. and because enforcement moves rights claims from the theoretical to the concrete, demonstrating the power of individual and community rights against the might of states, companies, and other powerful actors. Judges who are not independent and impartial can't uphold rights claims without fear or favor. A judge, for example, who fears dismissal or harassment by the government will struggle to find that the state committed acts of torture or that arrest and harassment of those who protest against the government is a violation of the right to peaceful assembly. Judges who are partial can't constitute a bulwark against discrimination. Independence and impartiality, then, are requirements of a good quality justice system, which is an essential component to access to justice, which in turn is essential for realizing protected rights. The independent and impartial legal system is also a key pillar of a democratic system of government. The judiciary is one of the key institutions of the health of that guarantee the health of a democracy. Independent judges guarantee that the same laws are applied to everyone, and they ensure that nobody is above the law, whatever their level of power, wealth, or political status. They ensure that society is governed on the basis of predictable laws rather than the will of a leader. An autocratic system of government poses a potential threat to all of the rights enshrined under human rights law. If there's not an effective check on the might of the state, governments can be free to subject their opponents to surveillance, harassment, arbitrary detention, and even torture. This makes it all the more alarming that we're living in an age of rising authoritarianism and autocratization and democratic backsliding, in which the rule of law is coming increasingly under threat. Protecting the independence and impartiality of the judiciary is a vital means of shoring up rights-promoting systems, as well as ensuring that individual right claims receive a fair hearing. Given the centrality of independent judges to the realization of human rights, what threats to judicial independence should we be alert to? Well, I think you've already spoken about potentially all of them, but I'll just talk about a few of them that I've seen in the course of my work as a special rapporteur. And there are two specific ways that I've seen autocratizing governments or backsliding governments attempt to capture, undermine, and neutralize judges by undermining systemic controls that ensure the separation of powers and by harassing and attacking the credibility of judges in the justice system. Would-be autocrats erode the separation of powers in an attempt to make judges of one mind with the government so that they won't restrict or challenge the exercise of its authority. One way this may be accomplished is by introducing new limits on the power of courts to review the legality of executive or legislative action. Governments may also improperly assume control over disciplining judges, either indirectly by influencing the composition and conduct of judicial councils, which are often responsible for such matters, or directly by seizing the power to sanction and remove judges from office, or by threatening impeachment against judges for reasons relating to politics. Additionally, judicial independence may be undermined through changes presented as reforms to the nature or composition of courts. Political actors may take increased control of judicial appointments and promotion, or alter judicial term limits. It's important to note that countries enjoy a wide discretion in the constitutional models they adopt, including, of course, the structure and composition of their courts. And court reform may be pursued for a wholly legitimate and rights-enhancing aim, but any reform process must not have a negative impact on judicial independence. When assessing whether court reforms have undermined judicial independence, the full picture is relevant, including the mode of appointment of a court's members, their term of office, the existence of guarantees against outside pressure, and whether the particular court presents an appearance of independence. In addition to undermining independence by eroding the separation of powers, political leaders may discredit, harass, and attack judges so that they fear to make decisions that will attract the ire of politicians. And when they do, they may not be trusted or supported by the people. In General Comment 32, the Human Rights Committee made clear that states must protect judges against intimidation. But in countries around the world, we see that judges are subject to threats and attacks, both in person and online. And many states fail to provide adequate protection for judges or accountability for perpetrators of such attacks. Even worse, we see governments themselves, government officials, who are sometimes the very sources of harassment. States can undermine judges' credibility and status in society by making public statements that denigrate judges, that also may even just attack the legal profession more broadly. Such criticisms may have limited or no basis in fact, or they may be based on reckless misinterpretation of judicial decisions. Abuse of this kind often decries judges as elite, out of touch, and failing to respond to the will of the people, particularly when they take decisions that run contrary to the wishes of the government. Of course, judges are not perfect, and it is vital that states do not punish or censor legitimate criticism of public officials, including judges and judicial decisions. But judges should benefit from the general protections afforded to all citizens, not to be harassed, defamed, or otherwise attacked. If these are some of the myriad problems facing judicial independence, what are some of the solutions? The first is to remain vigilant to threats and to respond to them. And I think this is especially important for the bar, because the bar has a crucial role to play in defending the role of independent judges. To ensure that judicial reforms are appropriately questioned, debated, and challenged when they seem to be an encroachment on independence, and to ensure that individual judges receive support and protection when they fall victim to unwarranted attacks. In my role as Special Rapporteur, I'm committed to ensuring that concerns about attacks on individual judges are brought to the attention of governments and the international community, as well as highlighting patterns and identifying and disseminating best practices for combating such threats while upholding human rights. It is also necessary that courts and contemporary legal orders are not left to defend their role in liberal democracies on their own. Civil societies and the bar can help protect domestic courts in a bottom-up approach, pushing to highlight the importance of independent courts for overall peace, freedom, and legal certainty. And there are other important positive steps to be taken. Many actors who want to undermine judicial independence have claimed an alignment with the people against elite judges. As advocates for the rule of law, we must look for a way to counter this narrative. But there is some truth in the argument that conventional legal systems can be remote, alienating, and often inaccessible to many. If we want the rule of law to remain a sufficiently potent force to protect democracy, we must democratize the rule of law. This involves ensuring that legal principles are understandable, effective, and potent, that legal systems offer solutions to the justice problems that people encounter in their daily lives, and that everyday people can understand, access, and support the judges in their country who protect their rights on a daily basis. I look forward to the discussion, and I thank you again for this opportunity to be with you.
Thank you so much, Meg, for such an illuminating presentation on the scope of your mandate, the different processes and mechanisms which can be engaged in order to utilize your mandate to address concerns around judicial independence. But also thank you very much for reminding us also about the legal standards themselves, which define what judicial independence looks like. At this point, I would like to quickly hand over to David, who will manage the last session concerning presenters. Then after that, we are going to have a plenary, and then we close. Over to you, David.
Thank you, Justice. And just to confirm to Prof that ICJ Kenya put in its submission in response to the call that was put out on safeguarding judicial independence. For the next speaker, we have Dr. Mercy Deche. Allow me to introduce her and then invite her. Dr. Deche is a highly esteemed advocate of the High Court of Kenya with a wealth of experience in legal system. She has served as a commissioner and vice chairperson of the Kenya Judicial Service Commission. She has been at the forefront for advocating for justice, particularly in ensuring equal participation of both men and women in all professional spheres. She has an extensive career spanning over 27 years in legal practice as an advocate of the High Court of Kenya, She has been able throughout these years to demonstrate deep engagement with various aspects of the rule of law within the justice sector. Additionally, Dr. Deche is an educator and has served significantly in academia and teaches at the University of Nairobi for now a decade. She has a diverse background which extends to consultancy and research, therefore enriching her understanding of legal dynamics. Recently, in her role as the immediate former vice chair of the Judicial Service Commission, she played a pivotal role in shaping policies at the highest level for the Kenyan judiciary and the broader judicial system in Kenya and in East Africa. Dr. Deche, as a former commissioner of the Judicial Service Commission and an esteemed educator, I welcome you to elaborate on the measures that should be taken to address challenges in matters of judicial independence. Karibu sana, Daktari.
Thank you very much for the introduction, and I want to also thank my predecessors, Margaret, Faith, and the CJ for their presentations. And thank you very much, Chief Justice, for reminding us that threats do not always come from the executive. And you reminded me of an uncle of mine who offered prayers for me when I joined the commission. And in the prayer, he thanked God that, and I quote, now our children will get jobs. And he's since passed on, and I always wonder whether my conduct may have accelerated his death. But anyway, I've been asked to handle the issue of measures to address challenges against judicial independence. And I could come up with so many measures, but because of time, I was actually only asked to confine myself to 10 minutes. I will only flag out 4. But I'll start by saying that the structural design, mostly in our constitutions or in our legal frameworks, they are normally not faulty. We normally have a kind of a textbook independence, especially in Kenya, judicial independence, but the problem is in the implementation and the practice. And I want to flag out 4 measures that can be taken, and this is especially drawn from my short stint at the commission, that measures that can be taken to safeguard further judicial independence. And I want to start by reposing the primary responsibility of judicial independence on the judiciary, and to a certain extent, the Judicial Service Commission. And what I'm talking about is the question of agency. For judicial independence to be safeguarded, it is critical for the judiciary itself to appear to be in control of its own space. And this is where now we are talking about judicial courage. This is where judicial courage comes in. And I would say that it should exist at 2 levels. First and foremost, at the level of the leadership of the judiciary, and of course, of the commission. But here I am focusing more on the judiciary. It should communicate a posture, and which should be followed by actions and even language, a language that communicates that, hey, we are here and we are an equal co-arm of government. We are here and we are not falling over each of ourselves to please anyone. And by anyone, I don't only mean the executive. You can refer to that long list that was given by the Chief Justice Mutunga. We are not falling over ourselves to please anyone. We are here and we are not available for courting. And we are here and we are not available to transact or to discuss anything behind the tent. Those of you from Kenya will understand what I mean. Or to discuss anything outside the constitutional framework. And I agree with Faith that there is nothing wrong with having discussions in the spirit of interdependence with other arms of government, including the executive. But those meetings and discussions should be, they should not fortify the perception of lack of independence. So when the meetings are held, the how and the why are very, very important. So that is as far as the leadership is concerned. But the second level where really judicial courage is needed is when it comes to the work of individual judges and magistrates. And here, judicial courage would be demonstrated by the judges and magistrates all over, developing a kind of a consciousness that shows the need for them to continue making pronouncements without succumbing to pressure from any direction. And this is doable because even in the dark days of the single party dictatorship, we had the likes of the late Justice Madan. We even had contract judges who did not, as it were, have security of tenure, who could stand up to the executive, like Justice Stockball, Justice Frank Shields, Justice Caulfield. They all stuck out their heads and stood up against the executive. We've read about judges in Uganda who have done the same. And we also have a lot of them in Kenya that I cannot name for their own safety and security. So first and foremost, judicial courage is paramount. And this leads me to my second point. And this is integrity. You see, judicial courage requires a certain level of integrity, both personal and professional, because it cannot coexist in corruption, in decorum, in decency, in propriety. It cannot. In fact, the two are mutually exclusive. You know, a corrupt judge or a magistrate, for that matter, is a very vulnerable human being. They are very vulnerable to the machinations of the executive. They are also vulnerable to people who have information about their improprieties. So you cannot do certain things. You cannot practice corruption in the morning, and then in the evening you think you are someone who possesses judicial courage. So the two go hand in hand. And indeed, we know that judicial independence and accountability go together. So what am I saying? I'm saying that it's imperative for the integrity mechanisms within the judiciary and of course the JSC to be reinforced. I'm talking about the JSC's complaints mechanisms and others by the judiciary, like the ombuds, the judiciary ombudsman. And may I add a third mechanism? This is a system of self-introspection. It is critical for the judiciary to develop a certain system of self-introspection where they voluntarily seek feedback from the consumers of justice, and where they ask, who are people saying that we are? Is there something wrong with us? And what is this? It was tried out in Kenya in 2019 with some degree of success, where people came together, the media, the executive, parliamentarians, the devolved government, and there was a candid conversation on what are people saying out there that we are. And in fact, if Jesus himself asked people, who do people say that I am? I think the judiciary should think of doing it, and doing it periodically, just so as to reinforce that aspect of integrity. Let me leave it at that. We can engage further during the Q&A. And I go to my third point, and that is allies. For judicial independence to be safeguarded, although I started by saying that by reposing that responsibility on the judiciary itself, I think it is important for this unloved child. I always look at the judiciary of this unloved child who is always blamed when the fire, for problems at the fireplace, all the problems at the fireplace. And it's important for this unloved child or this least favorite arm of government to have people who talk on their behalf. what I would call an arsenal of allies to speak out for them every so often, and when need arises, of course, not to defend them when they are in infractions, but to just give the additional voice. I'm talking about the bar associations. I'm talking about ICJ. I'm talking about retired CJs and judges. I have just heard that they are elders, some form of elders. Yeah, those elders, the East African Law Society and other regional and international bodies. And by the way, apart from those organized bodies, the judiciary also needs the public to speak on their behalf. In Kenya, we call the public wanjiku. And I believe the best kind of an ally to have at the judiciary's corner would be the ordinary citizen. And the CJ alluded to it when he talked about our constitutional frameworks, especially in Kenya, where we have "with the people." The ultimate power of the people belongs to Wanjiku, to the ordinary citizen. And when you have that ordinary citizen, or when the judiciary has that ordinary citizen ready to stand up and defend them, I think there is no better safeguard for judicial independence than that. But remember, for these allies to be persuaded to stand up for the judiciary, they must be convinced that the judiciary is transparent in its processes and its outcomes. And from where I sit, the best way of ensuring that the public is on the same page with the judiciary is where the decisions, there is flow of communication, including the communications that, of course, most of them are judgments, especially in sensitive cases. If we could have or reinforce this practice, it normally pops up in Kenya once in a while, where we have the decisions in sensitive cases unpacked in a language that a common mwananchi understands. They understand, yes, the judiciary is saying this, and this is why they got there. They will understand that these processes are transparent, however way it goes, and the outcome is also transparent, and they will be the first to stand up to defend the judicial independence. And apart from Wanjiku, I'm also thinking of other allies, like the independent commissions. For instance, in Kenya, we have all these independent commissions with a mandate to speak out about one issue or the other. I have in mind the Kenya National Commission for Human Rights, the Ombuds, the Gender Commission. They all have a mandate to speak out. But in all these, during this season, when we've had so much attacks from against the judiciary from the executive, there has been a loud silence from even those commissions and the agencies that have a mandate to speak. So what I'm saying is that if we could have that arsenal of allies, I think it would go a long way in safeguarding judicial independence. But of course, when I talk about the agencies and the independent commissions, I mean the ones that are actually independent in reality, not the ones that are weaponized or captured by the state. And then the fourth strategy, or the fourth measure for me, which is very, very important, is the financial independence, interventions to ensure that our judiciaries are actually in reality and in practice financially independent. When I talk about Kenya, when I think about Kenya, the truth is, as far as financial independence is concerned, the judiciary can hardly breathe. Because if I may take over the metaphor of the knee on the neck, there is actually a knee on the judiciary's neck. Actually, not one knee, but 3 knees. So first and foremost, there is the knee of underfunding. The judiciary in Kenya, for instance, has been perennially underfunded over time. And when you compare the budget of the judiciary with that of parliament, for instance, parliament has an allocation that is 3 times larger than that of the judiciary. And this is despite the fact that the judiciary has a larger, a heavier portfolio compared to parliament. And of course, the executive hardly ever complains about budgetary allocation, at least not in Kenya, if going by the renovations in State House and all the other grand trips all over the world are anything to go by. So there is need for the judiciary to be delivered somehow from this perennial underfunding. And I belong to the school of thought that proposes that the budgetary allocation of the judiciary be ring-fenced at a particular percentage. Currently, in Kenya, the budgetary allocation compared to the trillions that are there in the national budget, the judiciary budget is normally at around, it goes to as low as 0.4% of the national budget. If it could be ring-fenced to say even a minimum of 2% to begin with, not forgetting, of course, the international best practices are at 4%. If it could be ring-fenced to 2%, I think that would go a long way in making the judiciary functional and financially independent. And this is not unreasonable because we have already the devolved governments have their allocation fixed at 15%. We have the equalization fund at 0.5%. And I don't see why the judiciary should not enjoy such a fixed a percentage. And this would then solve the problem of leaving the judiciary at the hands of politicians who, like in Kenya currently, they are making pronouncements on the judiciary budget at any place you can think of, at funerals, at marketplaces, on sunroofs of their motor vehicles. Anyone is able to say anything about the judiciary budget. I think that percentage would assist. Secondly, the second need has to do with the judiciary fund. At least in Kenya, Kenya had a first and came up with a judiciary fund. I'm not aware that there's any other jurisdiction with that fund, and we all celebrated. But the truth is, it was a case of, or it has been a case of new wine in old wineskins. And why is this? It's because we have landmines all around that fund, both legally and operational. When it comes to the legal landmine, the fund was introduced, but the judiciary was not exempted, or the fund has not been exempted from the regulatory framework of the Appropriation Acts. Yeah, these Appropriation Acts that expire on every 30th of June. And what does this mean? This means that at the end of every 30th of June, the judiciary must return whatever money that they were holding, or whatever allocation that they were holding back to the treasury. And there will always be an unabsorbed amount. Why? Because the way the judiciary relates with treasury, and maybe Chief Justice thinks otherwise, but from my short experience, I always see like the expenditure of the judiciary comes under so much control. Currently, it has to be controlled by the treasury and the controller of budgets. And you find that because of the red tape and the bureaucracy, there will always be large amounts that cannot be absorbed. And I have a feeling that that is done by design. This is something that needs to be looked into, both the legal framework and the operational framework, especially the behavior by the controller of budget, whereby you find that the judiciary has to encounter a kind of they have to go through a pre-audit process before they have even expended their allocation. And then lastly, something that I think has also really been working against the judiciary as far as the financial independence is concerned is the whole mandate of the conflict between the mandate of the SRC, and that is the Salaries and Remuneration Commission, and the Judicial Service Commission, whereas the Constitution clearly states that the mandate of the SRC is around salaries, whereas the judiciary is supposed to has a mandate of over terms and conditions of the staff of the judiciary. You find that most of the times the SRC overreaches itself, and all the other arms of government agrees with the SRC. And you find that it becomes very, very difficult for the judiciary to function. What at the end of the day we have, because of this lack of financial independence, is that the executive or the agencies of the executive have set up a kind of a straw man, which they are then busy fighting, because without financial independence, it becomes extremely hard to function efficiently. You are set up for failure. So in conclusion, I would want to say that regarding the financial independence, there is need for further statutory intervention. We cannot just sit back and celebrate we have the judiciary fund. And apart from that statutory intervention, there is need for goodwill. I don't know how goodwill is cultivated. I think both goodwill and good manners. There is need for goodwill and good manners from other executive agencies, from the Treasury, the Controller of Budgets, and the SRC. Everyone should identify their lanes and stick to them. Allow me to stop at that, and I would be happy to engage further in the Q&A. Thank you very much.
Thank you so much, Daktari, for that very elaborate presentation. Thank you for sharing insights with us on how then can we address the challenges that we face when it comes to matters judicial independence, the reflections on the tripartite nature of government, and that the judiciary is not a smaller brother, that it's an equal arm of government as to the rest. Thank you for reminding us that whoever feeds you controls you, that you need to have and operationalize the judiciary fund, not just in textbook, but in actual measures. Quotable quote that I've gotten is that a corrupt judicial officer is a vulnerable judicial officer. Thank you so much, Dr. Deche. I take this moment to invite my senior and brother, Dr. Evans, to take us through the next sessions.
Good evening, ladies and gentlemen. Thank you very much, Mburu. Our time is well spent. I will want to do some little bit of housekeeping. Then we move to the questions that we have deducted from the audience that has been faithful since the hour of 2 o'clock. Thank you very much for being with us. Before we go to the questions, may I quickly recognize the following persons who have joined us as well. We have Justice Lillian Tibatemwa. We have Lady Justice Jemima Kelly from Kenya. Welcome, Your Lordship, Your Ladyship. We have Justice Moses Chinengo, Professor Sarah Kinyanjui, Mr. Peter Wendo, thank you very much, sir. We have Commissioner Jacqueline Ngutia from Kenya, Senior Counsel Moses Kurget from Kenya, thank you very much. Now we have a couple of questions. Panelists, our time is well spent. We have already presented. May I ask that we limit strictly ourselves to 2 minutes per question. We have the first question to Faith Odhiambo. Faith, the question is this: if elected the president of the Law Society of Kenya, the first one in post-2010 dispensation, how will you bridge the gap between the bar, the executive, and the judiciary? Faith, over to you, 2 minutes maximum.
So let me just say this. I think LSK plays an important role as advisor of the executive and a key stakeholder in the judicial infrastructure. And with the judiciary, we have a working relationship. by virtue of the fact that a lot of the services that are offered by the judiciary, we are the major consumers of the same. And so what I'll do is foster that we have more meetings together, and when I say together, I also mean including our branches as one, that we're able to address the challenges that are met by members and members of the public on a day-to-day basis. With regards to the executive, I think we will continue to hold them accountable. The only way I think is there's sometimes the beauty of that tension between the executive and the judiciary is because the two arms of government have different mandates that they must adhere to. And so the role of the LSK will be to hold the judiciary accountable, but most importantly, the executive as well. I think as Mercy Deche said, each should play by their lanes. Let the judiciary serve the people of Kenya. Let them do their work. Let them execute their promises, however, within the ambits of the law. And that is why we will stand with the judiciary to uphold the rule of law, and we shall be consistent to that extent. Thank you.
Thank you very much. Thank you very much, Faith. Your Lordship, Professor Willie Mutunga, your Lordship, perhaps you will help us with this. There's a question here. How can we bridge the gap between justice systems and the public in Kenya, fostering trust and understanding so that the citizens can be energized to see through the political rhetoric and hold their leaders accountable? This is a question from somebody called Mataiwa Busieka. Your Lordship.
Okay. Let me just say what is being done. A lot of you know what's happening about the African justice systems, because the truth of the matter is we should never forget that the formal justice system serves only 5% of Kenyans. Because the 95 don't believe that they will get justice there, or it's too expensive. So the African justice system is an inroad, to that discussion, with the people. And the point I made that the judiciary needs to have, a following so that people can also, defend what they do. And this is the integration which is being now discussed. Is very interesting. How do you integrate what is called informal? But the informal actually is a formal, because the majority go to the elders and councils and pastors and whoever else. So the integration will give the judiciary, I think, even more opportunities of getting the people to basically understand what they do and get that following, which I think is very, very, very important for defending the integrity and independence of the judiciary. Thanks, Evans.
Thank you, Professor. Dr. Deche, this is your question. You mentioned that there's a responsibility that civil society and civilian citizens have to in educating themselves on the threats of the rule of law and judicial independence. What role do you think the media plays in East African countries to shape these conversations and build confidence in strengthening the rule of law? This is a question from Diana Godana. Dr. Deche, the floor is yours.
Thank you very much, Evans. You see, the media, the media will rarely not adjust itself to a certain agenda, and the media likes what is sensational. Yeah, so one cannot overly rely on the media, but it is then for the judiciary to reach out to the media and in a professional way, and in fact, even invest in professional media experts to engage the media, because when we engage as lawyers, as judges, we engage, it's like we are walking around a landmine. So I think it should flow the other way around. The judiciary now reaching out to the media and packaging themselves in a way that they do not fall into this danger of having their story sensationalized in a negative way. So what I would recommend is the judiciary should actually invest in properly in what are these people called? These people who present a very positive image to you and to everyone else. Yes, those ones. The judiciary needs to invest in that. Thank you.
Okay, thank you. Faith, this is a question you'll attempt for us. Can the freedom of assembly, the LSK the other day called a demonstration, can the freedom of assembly and the right to protest or social movements be a sufficient tool to mitigate the threats of judicial independence from an acrimonious executive in the context of East Africa? That's a question from Mr. Tioko. Faith, your question.
Mr. Tioka, I think it's one of the steps, but I don't think it's entirely all that can be done. If you look at the history that our country has had, and even in the East African region, picketing and, protesting on the streets has been one of the elements. And I would dare say that in certain political elements where you put even the entire country at a standstill, it has made a significant impact, because you have the business people talking and the investors who are potentially looking to come to the country when they are not ready to work in that jurisdiction. It makes the powers that be sit down and think and rethink whatever strategies they have. And even peaceful protests, I would like to say, like Mahatma Gandhi carried out the same, to extent even of, just sitting and having hunger strikes in protest. And they have had significant impact. But I don't say that's the only impact that can be there. I think there are other tools that we can use. The Law Society has a history of even petitioning for dissolving of parliament. And because I would say in our country, parliament has been part and parcel of, some of these excesses that we see and threats that the judiciary are using to wield against the executive are using to wield some level of power over parliament. So there are also petitions that you can do, even against certain executive officers, even to the head of state. So that is just one of them, and I think it's quite effective as well. Thank you.
Thank you. Professor Mutunga, Your Lordship, what can we do as citizens in collaboration with the judiciary if the political class continues attacking the judiciary?
Well, I said very clearly that one of the untested provision in the Constitution is Article 1. Why don't we try to withdraw our delegated power and act directly? They think what that means, because I think it's very powerful if a civil society, the people see what is being done. It's wrong, all right? But in the context of Kenya, don't forget that for that to happen, we've got to quit politics of division, because that's how these things become difficult. That's how dictatorships happen in our country. Ethnicity, monetization, generational divisions, etc. Even now, these days, we are being divided on the English Premier League. So we've got to basically love the motherland and look up, focus on our material interests, so that the Constitution has great sights of checking the dictatorships if we actually act, as a people who love the motherland.
Thank you, Professor. Dr. Deche, I'll want you to give us the response to this one in a minute. what preparation is available to any judges who are purported by the state to be corrupt or who face unwarranted attacks online? This is a question by Diana Nyawanda. In essence, what do these judges do? You're being attacked unfairly. Over to you, Dr. Deche.
Thank you for that question. I think there are some who have actually filed suit, which is pending in court from the delays in the appointment.
Did we lose Dr. Deche?
I think, can I be heard?
Yes, I can hear you now.
Yes, I'm saying that there are those who have experimented with the court system and filed suit against the executive. Think of the delayed appointments, those who are kept in limbo for long over allegations of corruption. So I think the waters can be tested there. They can also test the waters around impeachment, but as so they could try that.
Okay. And Dr. Deche, while you're at it, and being a former Judicial Service Commissioner, perhaps you could try this from Helena Kithinji, who says this: I like the discussion on judicial courage. What additional systems and practices within the judiciary should be put in place or strengthened to encourage or reward courage by individual judicial officers? How do we reward courage? Dr. Deche, to you again.
I'm not sure you are rewarded for doing what exactly you are called to do. Okay. I mean, they're doing what they are supposed to do. Okay. Apart from recognition, and maybe a person who would have a better answer would be the CJ, because he talked about glorifying that courage. He can unpack it for us. But for me, you are called, you took oath to be courageous. Should we reward you any further than that? Thank you.
I don't know if Professor Mutunga wants to chime in on that one.
Kithinji's question.
Yes.
What was it? You know,
the question was, what do we do in terms of rewarding those judicial officers that have exemplified courage? How do we motivate them to continue exemplifying courage?
Yeah, there are a lot of things that can I mean, the citizens are free to glorify judges. That's you know, that's important over a particular decision, over you know, courage. It's freedom of expression, I think. And just the way it's important that judges also accept and respect their critics. It's a double, you know, it's a double-edged sword, because that glorification and the critique it's important, you know, in my view. But of course, if citizens think that some judges are courageous and they need to be glorified, what about asking them to run for office and become your presidents?
Thank you, CJ. Always philosophical, prodding us to think. Finally, I want Dr. Deche and Faith to give us a 1-minute response to this one. This is our final question. What East African countries are most independent, face the most judicial independence challenges, and what can be touted as the achievements from those countries that are most independent? What countries face the most challenges with judicial independence, and what are the achievements from those countries that can be said to be most independent in terms of the judiciary? Faith, I start with you. A 1-minute response to that.
I find that that's an interesting question. I wouldn't know where to pick and say this is the most independent or not. I think Kenya and I would say maybe Uganda and Tanzania, the countries that face mostly the most judicial threats. And in terms of what have they done? I would say I found I don't see the fight in terms of the fight even by the bar in Uganda for judicial independence, in terms of even some of the rulings that come from that jurisdiction. In terms of Tanzania, I would only laud the time of the previous president of the bar, and we saw him standing out quite strongly, irrespective of the popularity of the head of state that would be. And even by the statements that were coming from the head of state with regards to her apprehension with members of the bar and the strong positions that they take, I would say that jurisdiction had some sort of wins with regards to the strong positions they take. In Kenya, I think we also suffer quite a bit of challenge, particularly in this dispensation. And last dispensation, I think the former president, Uhuru Kenyatta, was known for disregarding and disobeying court orders. And with regard, and I loved the fact that there was quite some fire, particularly in the High Court, to push back with regards to the executive and continue to raise their voice through their rulings. They were strong. We have the Justice Odunga, Professor Ngugis, the Justice Mrimas, who stood strong and even held some of those members personally responsible and liable to even pay fines and serve sentence, even after their terms, and they had to rush to the higher courts when they realized the weight of those decisions that were made, that they would even serve term after, their term in office ended. So I would say that was part of the gains that we saw the judiciary coming out quite strongly, that I quite commended. And even in this dispensation, we've seen the head of state coming out first to say they would respect the rule of law. But now, as we see, the trajectory is changing fast. We are hoping that we'd have more of those judges standing firm and standing strongly, that we do not have courts as gatekeepers for the executive. Okay, thank you. Dr. Deche, you give us the final word.
Still on the question of
yes, independence.
The dwarfs is taller.
Yes.
Okay, I think Kenya is ahead as far as judicial independence is concerned, and this is not something that was achieved overnight. We are talking about a long history of struggle where people lost life, limb, and liberty for us to be where we are. So that's where I would put Kenya. There are those who are still struggling. I had the privilege of compiling the status of rule of law in East Africa. I was with my colleagues from the other East African countries, and the struggle out there is real. I can think of South Sudan, where there was not even a presenter who was bold enough to present that report. And that tells you about the whole state of rule of law there. And of course, judicial independence is a factor of rule of law. So I can say comfortably that Kenya is ahead, and the others, we need to stand with our sisters in the region. Thank you.
Thank you very much. Our time is well spent. Thank you very much, ladies and gentlemen. We acknowledge the fact that we had a lot of questions that came in during this session. Unfortunately, we are out of time. We will be certainly continuing with this engagement. Watch out for the next webinar, if and when it will be organized. Mine is to encourage us to exhibit what Deputy Chief Justice South Africa Emeritus Digang Moseneke calls the courage of principle. Do not waver, do not falter. Judicial independence depends on courage. Over to you, my brother, Dr. Justice Mavet Zenge. Thank you.
Thank you, Senior Counsel. Thank you, colleagues. So we have two last quick things to do. But before I summarize what has gone on and outline the way forward in terms of what we're going to be doing to deal with the issues that have been raised here. I would like to quickly give this opportunity to Justice Moses Chinengo, who is the chair of AJJF, to just make submissions within 2 minutes so that we can move and close this. Over to you, Justice Chinengo. And remember to unmute yourself. Justice Chinengo is probably experiencing a technical glitch. Maybe we can have Justice Lillian Tibateno from Uganda. Okay. In that case, let me just quickly summarize what.
Hello.
Yes, Justice Tibateno, please go ahead. You have got 2 minutes.
Yes, it has been an enriching discussion, and thank you very much. I have listened to threats. I have listened to possible or potential defenders of the independence of the judiciary. And what I would want to say is that I think we also need to reflect on how we can empower the people or institutions which we think have the are potential defenders of the judiciary. A lot was said about the common person or Wanjiku. The question for me is Wanjiku, does Wanjiku have enough knowledge and understanding of the role of the judiciary within a democracy? So I think as judiciaries, we must come out and clearly enable other people who would be able to come and defend us, understand who we are and our role, and how, if they defend us, it would be for their own good. I was also thinking about civil society. In Uganda, the executive can take away your license to practice. So who can then defend civil society? Who can defend the bar when they think that if they come out, their licenses can actually be taken away from them? And I think these are questions now which we must take over to another webinar. How do we empower those who are supposed or expected to defend us to defend us? Thank you very much.
Thank you, Professor Justice Lillian Tibateno, for giving us that challenge. So, colleagues, I think I will summarize the discussions today in this way. First, we had a presentation on sources of threats, and I've already summarized the threats earlier on. I'll just add that the executive has been identified as a major threat, a major source of threats against judicial independence. We also had a discussion around the typology of threats. In other words, what do these threats look like? I think what has been highlighted here is that there is harassment of judges, there is premature removal of judges who are independent, there is deliberate underfunding of judges. Those are some of the major types of threats against judicial independence in East Africa. We did not just try to diagnose the problem, but we also tried to propose solutions. And of course, led by Dr. Deche, we managed to identify a number of solutions. One is that when we are appointing and selecting, when we are selecting and appointing judicial officers, we must look for people who are fiercely courageous. And I think the point was made there to illustrate what courage means. Second, we must identify men and women who are of integrity. Dr. Deche said, judges who lack integrity are the most vulnerable to interference. Solidarity is key. So it is incumbent upon the bar associations the networks of judges such as Africa Judges and Juries Forum, network of juries such as ICJ, Kenya, and the public themselves to stand arms in arm with the judges who are independent, especially when they are under attack. Then there was also suggestion to ring fence resources to ensure that judiciaries are adequately funded. There was a question which I think speaks to solutions, and that question was around the role of the media in undermining the independence of the judiciary. And I think the discussion that ensued on the basis of that question was we need to engage the media to build their consciousness, but also to understand them better, so that they themselves can also understand the way the judiciary works. The way forward, ladies and gentlemen, comrades and friends, is that we will be moving to Southern Africa to conduct a similar discussion, looking at Southern Africa. And we hope that out of each meeting, we will produce a write-up, a communique. This meeting has also been recorded. So we will release the recording and the communique, which outlines these issues that I have flagged out, with, of course, commitments from ICJ Kenya, Southern Africa Chief Justice Forum, Tanganyika Law Society, East Africa Law Association, and Africa Judges and Juries Forum to continue working together to address some of these issues that have been raised. On that note, ladies and gentlemen, I would like to thank all of you for making time to take part in this webinar. We started at 90, with 90 participants, which already was a huge number. And we peaked at 191 participants. We are now ending at 109 participants. That is incredible. Those are incredible numbers, which then demonstrates that the people out there are actually concerned and interested in this particular subject, because the independence of the judiciary is at the core of constitutional democracy. So I would like to thank all of you. I would like to also thank our panelists for taking time to come and lead in the discussions that we've had. I think we've benefited a lot. We have benefited a lot from your insights. I would like to also thank the 4 organizations that teamed up to organize this webinar. It's ICJ Kenya, East Africa Law Society, Tanganyika Law Society, and Southern Africa Chief Justice Forum, working together with Africa Judges and Juries Forum. We hope to see you in the coming month when we have a similar discussion focusing on Southern Africa. Thank you, ladies and gentlemen. Have a wonderful evening.
Thank you.